afternoon. My name is Brad Neese, Managing Editor of EmployerLINC, and I'd like to welcome you to the latest edition of McAfee & Taft's EmployerLINC webinar series. Today's topic is generating quite a bit of attention as employers, especially those in industries most targeted by OSHA, are learning about the agency's latest memorandum that takes direct aim at workplace safety programs, employee safety incentives, and the enforcement of safety policies. Has many wondering what OSHA expects employers to do to maintain a safe workplace if such programs and policies are restricted or eliminated. But before we begin, let me point out a couple of things. First, this program has been approved for 1 hour of general recertification credit through the HR Certification Institute. And in the next day or so, we will send everyone who pre-register for HRCI credit an email with the program details. And second, for those of you who are familiar with our webinars, normally we have a Q&A tab where participants can submit questions. However, we will not be doing that today. This topic still remains a very unsettled issue and by its nature leads to case-specific questions that we can't answer in this forum and quite likely doesn't even have clear, concrete answers just yet until the courts and others have had a chance to weigh in. If you have case-specific questions regarding this issue, we recommend that you contact counsel for further guidance. Our panel today will be led by McAfee & Taft employment attorney Nathan Watley. Joining him is fellow employment attorney Roberta Fields. Both of them have extensive experience representing employers before regulatory agencies like OSHA, as well as handling employment litigation matters before federal and state courts. Nathan and Roberta both represent clients in industries that are frequently targeted by OSHA and other agencies for inspections and audits. Also joining us today is attorney Chris Paul, who has extensive national and international practice focused on regulatory, health, safety, and risk management matters, primarily in the highly regulated midstream, energy, manufacturing, transportation, and aerospace industries. Some of you may already know Chris as a frequent speaker at national industry conferences and forums discussing regulatory and safety issues. He is also the editor of another McAfee & Taft publication, RegLINC, which provides legal information, news, and commentary to employers in these highly regulated industries. In fact, we'll be expanding RegLINC in the next month or so with its own dedicated website, much in the same way we've developed EmployerLINC, which has been very well received. Now, before we jump into this OSHA memorandum, let's start with a little background information. According to the Bureau of, I think I've answered just a little bit too far there. According to the Bureau of Labor Statistics, the number of reported workplace injuries, illnesses, and fatalities has been declining over the last 8 years. In 2003, there were 5,575 reports of work-related fatalities. By contrast, in 2010, which is the most recent year available, that number dropped to 4,690 fatalities, a decrease of 885 incidences. That's a 16% decline. The Bureau noted it was the second lowest total for workplace fatalities since the census was first conducted in 1992. The trend is even more dramatic when it comes to workplace injuries and illnesses reported among private industry employers. In 2003, there were just under 4.4 million cases reported. In 2010, there were less than 3.1 million reports, a decrease of more than 1.3 million annually recorded cases, and that represents a 30% drop over those 8 years. So let's quickly take a look at that graphically. This chart is from the Bureau of Labor Statistics, and it demonstrates the decline in workplace injury and illness incidence rates in the private industry. That top blue line shows the total number of reported cases per 100 full-time employees for each of the last 8 years. I know it's kind of hard to read on your screen, but we'll have a downloadable version that you can look at a little closer. In 2003, there were 5.0 total recordable cases. That was the incident rate. In 2010, it dropped to a rate of 3.5 instances per 100 full-time employees. Again, like the other stats showed, that's a 30% drop over that time period, and you can also see that it's been a steady decline. This next chart shows that all sizes of employers have seen a decline in the incidence rate. It's probably a little hard to see the labels on this chart again, but the smaller employer size which is less than 10 full-time employees, is on the far left, and the largest company size, which is more than 1,000 full-time employees, is on the far right. The mid-sized companies, those two in the center, one representing 50 to 250 employees, and the other 250 to 999, saw the largest percentage drops since 2006. Now, finally, I threw in this chart because I thought it was interesting to see that in 2010, private industry, which is represented by the blue bar on the left of each column, had a significantly lower incidence rate of workplace injuries and illnesses than the public sector, by as much as 43%. That begs the question, who's doing a better job in improving workplace safety? So, from an employer's perspective, it sure seems like all the time and money invested in workplace safety programs is paying off. And the government's own statistics appear to reflect that conclusion. So, what's the problem? Nathan, as we turn to you, can you help us understand why OSHA is issuing guidance that seems to be trying to fix something that doesn't appear to be broke, and specifically taking aim at policies and practices that seem to be achieving the desired result?
Thank you, Brad. Good afternoon, everyone. Yeah, the statistics on workplace safety would belie what we're seeing coming back from OSHA in the last few years. While there's been a decline in reportable injuries and apparently increased emphasis on safety by industry, there's been a very strong sea change at that agency. In fact, in all of the agencies under the Department of Labor. And I think it's driven primarily by changes from the top. The leadership there, whether it be the Commissioner of Labor or those at the top levels of OSHA, have made it known that they're becoming much more aggressive and changing from what historically I think all of us have seen as an agency that's been pretty easy to work with and to work through issues and to act as a partner with in a lot of ways, to one that's much more taking on the mold of some of the other federal agencies toward aggressive enforcement and looking for ways to find violations rather than to necessarily work towards safety. Along with that new attitude, I think we've also seen an increase in budget for that agency and definitely an increase in manpower. The number of investigators has gone up sharply across the country, and we're seeing more targeted inspections and more time spent in inspections than we have in the past. So, again, I think that this is a result of an ideology and sort of marching orders coming down from OSHA rather than a reaction to a poor safety record by the public or by the private industry. One of the ways that they've done that we want to talk about specifically today is this memorandum that came out. This was issued in March of this year, issued as a guidance to field compliance officers and also to whistleblower investigators. And, of course, some of the listeners may have or may not know that there really are two separate people usually that get involved with this. There's a separate set of investigators that deal with whistleblower issues than those that come out and do the inspections. And so different areas of this probably relate more to the whistleblowing side and then to the compliance side, but the memo is pretty wide. And as I said, it continues this trend that we've seen among the agencies and of OSHA of greater scrutiny, stepped-up enforcement against employers. You know, one thing I didn't mention, you had those statistics with the charts going down. If you look at the statistics from the last 2 years, 3 years perhaps, of the fines and the penalties that have been assessed against employers, you'll see that number going up, not because of necessarily more violations, but because the amount of the penalties has been increased. And again, this is a mandate that, as we understand it, from taking the standard penalty for, say, a willful violation or, willful violation or a serious violation and increasing that by a large percentage. So this is part of that trend. I think it's something that we're probably going to continue to see as long as the leadership in OSHA remains the same. This memo focuses on practices and policies that the agency thinks may have some potential to discourage employee reporting of accidents or injuries, and that they say could violate Section 11C of the Act, which is the whistleblower statute. And let's talk a little bit about Section 11C just briefly. That section prohibits an employer from discriminating against an employee because they've reported an injury or an illness. It also has some language regarding the importance of reporting, the fact that reporting injuries and participating in those types of activities is protected, and then goes on to expound that if employees don't feel free to report injuries, everyone can be put at risk because a safety concern might be missed. Certainly there's some real laudable reasons behind Section 11C, and no one would say that whistleblower protection is not important. However, we want to talk a little bit today about how this memo approaches it, and whether we think it has the desired impact or whether it's something that's more problematic than helpful. One of the big things that's caused a lot of concern, and there's been some press on this even in the mainstream press, is the way the memo treats incentive programs. And OSHA has come out here and said that they have concern that safety programs that provide an incentive, either individually to employees or for work groups or facilities, when those types of incentives, especially financial rewards, whether it be bonuses or prizes, may have the impact of causing employees not to report injuries. Their theory is that if people know they're going to get a safety bonus at the end of the quarter, they're just going to work through the injury, not report it to their boss. They also talk about the potential for peer pressure to come into play and interfere with that. OSHA also states in their memo that the policies and practices of using incentive-based safety programs could violate the record-keeping and documentation regulations that they have in place, basically tying back into the idea that if an employee doesn't report it because he wants to preserve a safety bonus, that then the record's not made of an accident that occurred. I'd like to turn to the panel a little bit and talk as we go through these things about their ideas, some of their take on it, what they're starting to see from calls they're getting as we look at this. For instance, Chris, we've talked in the past about this idea of injuries going unreported because of a safety bonus, and how that might or might not be encouraged here. What kind of historical situations have you encountered, and what kind of intuitive sense do you have about the impact of these kinds of policies?
Yeah, I think there's a number of things I'd like to touch on in terms of that, and some of it really is bothersome because it's very presumptive, and it's almost insulting to both employers and employees in terms of how they'll actually go about implementing their safety programs and making sure they're actually effective. I want to start with this. OSHA generally has been a very, very good agency to work with. I think I'm echoing what Nathan said, and Roberta also has seen over the years. And to a large extent, what we're seeing here with the lack of clarity in this memorandum and with some of the conclusions that are drawn apparently without a whole real factual basis or looking at all the issues, this is really kind of disappointing because, to a certain extent, the issue is employers were almost ambushed by this because it was thrown out there and has gutted what a lot of folks have as their program. So,
right. I was going to say one thing that's lacking in this memo is any kind of historical analysis that the OSHA undertook to say we've seen these whistleblowers being targeted, or we've seen a large instance of underreporting or not reporting of accidents. Let's kind of look at the next slide if we could. And the conclusions that OSHA have reached about its safety incentive programs was that workplace safety could be compromised, Workers who report injuries could be subject to unlawful discrimination or harassment, and whistleblowers could be unfairly targeted for retaliation. Again, they don't come in with any statistical model to back that up, and frankly, in the audits and the investigations that I've been involved with, that's not been a situation that I've seen a big problem with. Roberta, have you encountered a situation where that's been something that OSHA has found to have happened?
No, Nathan. In fact, there's almost a distrust in this memo of employers and employees. There's a presumption here that for financial incentive, an employee would be injured and decline or fail to seek medical attention simply for a financial incentive at the end of the year. I don't think very many people would trade a T-shirt or a small bonus for a bad back that could have been fixed. And so they really reach a conclusion with this that I don't think is supported by common sense either. The law is pretty straightforward. I mean, you are protected. You can't be discriminated against because you report an injury or illness. So it's not like this memo was necessary to reinterpret the law.
No, I agree, and I think more than a reinterpretation, perhaps it was meant to again send the directive to those folks in the field that this is an area that the agency wants to scrutinize harder. And I agree with what you said about the assumptions that it makes. I think it doesn't give consideration to the motivating factors that would encourage an employee to report. In other words, it looks at the potential of a bonus to maybe have them not do it. But certainly if someone's got an injury that would otherwise be a lost time injury that's that severe, like you say, there's the physical factor of it. Are they going to live with that? And two, oftentimes that would turn into a workers' compensation claim that the employee could receive compensation from as well. So it doesn't really seem to balance the competing concerns that are out there.
In fact, we talked earlier that it upsets the reasonable balance that did exist between all of these competing concerns.
Right.
One concern, if I can just jump in here, and we're seeing this more and more, is agencies are tending to, I'll almost say, make law or make policy without going through the Administrative Procedure Act, where there's an opportunity for notice and hearing and comment from industry. And I think in this case in particular, it's pretty clear cut that if industry had had an opportunity to come back, I think they probably could have come up with maybe a way to, as Roberta just mentioned, maintain that balance, but address this potential concern that somehow some employees in certain organizations could be dissuaded from reporting. But to just jump to that conclusion is really kind of bothersome. And the only place we've ever seen that as being even a potential would be in organizations that, quite frankly, we would describe as pretty much dysfunctional to begin with. Most organizations have very active safety programs. They're really trying to do the right thing, and I think their numbers in terms of injuries and types of injuries are showing and demonstrating that they're just getting better and better. And safety is no longer necessarily, even in some organizations that are your really front-end players, being dictated as much as it's been a cultural thing where employees are looking out for themselves and looking out for their coworkers because they know they don't want to have to be the person calling up someone's spouse or kids and saying, hey, your mother or father got hurt because I did something stupid. So, we're in many ways, I'm really kind of perplexed, but I'm actually very disappointed that this didn't go through a bit more of a formal process. And to throw this out there and effectively gut some of the current programs really it's bothersome, and I think it needs to bother everybody who's looking at this.
Chris, you made the point, we were talking before this webinar about how other agencies, or another way to look at this is if you don't have safety as part of a bonus program that rewards employees for several different components, perhaps production, perhaps how the stock is doing, if safety is not a component of your year-end bonus program, the view might be taken that you didn't consider safety important.
Yeah, and that's a very, very good point, and it's right on target. The issue there is when we've looked at things over the years in compliance programs in general, and you can pull these threads out of whether it be the federal sentencing guidelines, some memorandum out of DOJ for prosecution of white-collar crimes and things like that. They always talk about the need for having an effective compliance program. In fact, some of the memorandum actually say that it can't be a program that just sits up on the shelf. The way we get to an effective program, there's a whole lot of different factors, but one of the factors that's been there for a long time has been to provide adequate incentives and assurances to employees that when they do the right things with respect to compliance, they will be incentivized to do the right thing. And to now say that this is not correct really leaves a hole in compliance programs overall. The OSHA specifically says in this memorandum, I think it's like 3 or 4 paragraphs into it, that they appreciate employers using safety as a key management metric, but they are concerned when management supervisory bonuses are linked to lower injury rates because they cannot condone a program that encourages discrimination against workers who report injuries. And that's the kind of statement that really needs a whole lot more support before I, as an employer, would take it and say, yeah, this is a real problem. I think it certainly is not. These programs, these safety programs, that are to incentivize employees and make them aware of safety issues. I don't see how they can be called something that encourages discrimination, because managers certainly aren't going to have to take the risk for a bonus of putting people in an unsafe position.
Right. But, and like I think we all agree that OSHA came to some pretty strong conclusions without offering a lot of support for it. Chris, could you talk a little bit more about what they've done to try to answer the obvious questions, what direction they have included for employers?
Well, OSHA suggests this whole idea of offering incentives that focus on individual and corporate efforts for safety and not necessarily on the results of those efforts alone. And some of the suggestions, quite frankly, they're good suggestions. And if someone said, what should we do going forward, there's not a whole lot wrong with them as much as it is taking away the back end piece of this. When we talk about metrics for compliance, we always talk about input and output metrics, and they're essentially taking away here, or at least handicapping a good output metric, which is measuring performance and then rewarding based on performance. And we can talk about that a little bit more later if you like. Yeah,
that'd be great. So why, I think we've touched on this, but why should employers be concerned about what's come out in this memo?
So if I'll jump in here and maybe just hit a few of these points that we laid out here in the slides so people can look at these later. One is this presumption against employers. They're essentially painting with a very, very broad brush and saying all employers are essentially, for lack of a better word, evil. And this presumption is that employers are going to use safety metrics as an output metrics to discriminate against employees. And that's just not what we've ever seen as the case. In fact, part of the irony and part of where we're struggling with this so much is in our experience, in my experience anyway, we've seen cases where the agency has come in and said, hey, you had an injury not because you didn't have good policies in place, because the company did, but because you did not adequately enforce those policies. Well, enforcement by its nature implies some level of discipline. And, it also raises for me the question of, what happens if you fail to take disciplinary action, if you fail to handle some of these problems and that employee causes injury to somebody else, you're really leaving yourself exposed. But in addition to the presumption against employers,
yeah, and on that point, Chris, I mean, I think Roberta can probably echo on this as well. I've seen in a number of citations that have been issued to clients that one of the exact things OSHA was complaining about was a failure to discipline employees who hadn't followed a process, and they didn't. They felt that wasn't enough of an enforcement. So again, you're getting pushed on the one hand that you've got to discipline people and enforce this, and on the other, they're wanting you to not use positive incentives either. So it's leaving a little bit of a conundrum. And I know we're going to talk more later. I think Roberta's going to have some material on some other aspects of the memo that talk specifically about discipline issues. But
I was going to say you have to worry about civil liability, too. If you have an employee who has broken several safety rules and you have not disciplined that person, then you are on notice that perhaps they are an employee that doesn't work safely. And it may be if someone gets injured on the job, there's some states that allow that workers' comp claim to be taken out of the workers' comp court, and you may have liability to third parties also. So just because if someone has violated a safety rule repeatedly and you know that, then if you don't take action, then you risk liability otherwise.
Yeah. It's interesting as we're discussing this, I'm thinking if, OSHA is going to say, well, that's not what we're saying. We're not saying, don't discipline, but effectively, if you really read through this, and maybe it was just poorly drafted, there's a real...
Everybody has a bad day, Chris.
Yeah, and everybody has a bad day, but I get real concerned because they're so concerned about these disciplinary actions, and yet in our experience, so many times we need to look for a history of enforcement of work rules to ensure safety, and
sure.
So there's a concern there.
What kind of solutions do we think are out there?
Well, some of the solutions are going to be leveraged off of what they said. Some of the concerns that are here, and we've talked about the fact that there's a presumption against employers and this removal of the potential tool in a safety program and things like that, and the fact that we're always looking for these other incentives and regulatory programs overall. One of the solutions is really going to be having organizations get to the point where they can get some definition from OSHA when OSHA says, and this is a quote, if the incentive is great enough that it dissuades reasonable workers from reporting injuries. And, that's a very subjective standard. What is great enough?
A T-shirt?
Yeah. And so you look at these things and you go, OSHA suggests, give T-shirts to the people on safety committees. Obviously, since that's being suggested, that's not great enough to dissuade someone from reporting. I would posit that gift cards and other things for good safety performance on a quarterly or a monthly basis. As Roberta pointed out, people aren't going to put their health behind the possibility of getting a small reward like that. And I think there's an underlying message here, and that is there's a concern that other employees who also want to get the awards will try to pressure employees not to report things, but I just have never really seen that in any workplace that we would consider normal.
I suppose you could have the, bad apple supervisor who really wants the bonus and so has made it known to his work group that reporting would not be appropriate. But since that's not the norm and it's not what we've seen, then to presume that everyone's like that seems unfair.
Yeah, it's much too broad a brush. It really is a terrible thing. The guidance that OSHA provides for us is, that they lay it out at the end of the memo. Tell people to identify hazards. Okay, that's fine. Participate in incident investigations, and I'll talk about that here in a second. This idea of getting T-shirts we talked about. Modest rewards. Well, I'd like some definition as to what constitutes modest for employees, and then parties for completion of safety training. That to me is counter to some of the other things that OSHA requires and other regulations require in terms of not only completing the training but demonstrating a knowledge of the training and an understanding, and then ultimately implementing that training so you have safe work practices, or in the environmental world, practices that protect the environment. So we'd say solutions. I wish they had gone a little further here and say, not just identification of hazards, but get folks to the point where they're out there actually, at best, preventing hazards to begin with, or two, when they see things that can be fixed, don't assume it's always been that way, and that way, therefore it's okay to go ahead and make fix. This whole concept of participation in incident investigations, I actually think that's a very, very good one. Again, I'm not saying it's a substitute for an incentive program, because I still think the incentive programs have a real strong place, but participation in incident investigations is a wonderful teaching tool for employees. It's consistent with other OSHA programs that really do have some tremendous value, like PSM with employee participation and things like that. So we look for that. Modest reward for safety ideas, yes, but again, we need the definition of modest. And in terms of the safety courses and stuff, it has to be more than just completing the training. We'd suggest, reward the employees who are actually teaching the training, because that's one way to get there.
Yeah, I think one of the things you kind of touched on was we need active engagement, or companies need active engagement from their employees for safety to work. And, whereas OSHA suggests incentivize people to attend a safety training class or going through training, we need something to incentivize them to be engaged in it. I think Roberta earlier brought up the idea of I come in and then you're taking a nap during the training or some other thing where you're distracted. So something like you just alluded to, I think, where they're involved in teaching it, coming up with creative ways to keep them engaged. And that's what the incentive programs have done, is have engaged the employees in the whole idea of safety. Not only do they avoid an injury, but, hey, there's a nice reward if everybody does what's necessary to keep the workplace safe. So that engagement is what I think employers are striving for, and then it's just difficult if OSHA is wanting to take away something that seemed to work and get that engagement. How do we replace that? If you have to scale back those things, how do we replace it? What more information do we need, Chris?
Yeah, well, it's. I think again that some of the definitions of what's going to constitute modest and what's going to constitute something they would view as dissuading, because certainly companies don't want to be hung out there with the potential for being cited for violations, based on the reading of this type of policy, because, on its face, it really does say these incentive programs are presumed bad, and presumed to be a problem. So we do have to have something to replace it. And I think, if you look back 20, 30 years, there's been a sea change, and it's not just the statistics, but even when you just deal with organizations, safety has really become, again, there's always the outliers, but in most organizations, very, very key and very, very ingrained in the cultures. And we'll see folks open meetings with safety moments. We'll have much more effective training being done, and frankly, OSHA needs to be credited with doing a lot of this, because they have pushed this along. I almost see this as a step backwards, because now all of a sudden we're left with, okay, now what if? So if we're sitting in a situation, I think we still need some of these definitions. We still need to be able to measure performance, because even if it's just for reporting and record keeping, you have to measure performance. Now, why then can't we take that and use that performance going forward as a tool? I think if we are going to take away these incentives, the employees need to be told why. Because
they may interpret it as a lack of importance towards the focus of safety.
And Roberta, I think that's really, really important. Is they may interpret it as the company saying we're going to backpedal, and we're no longer willing to invest in these incentive programs because safety is not as important to us anymore. And so it's really sending that mixed message. I think maybe if I was looking at this, I'd say, what do we need here? We need a mechanism for disciplining non-reporting. And, do we always know when there's been an injury? No. But if we ever do find out, there should be a clear mechanism for that. And that in itself could resolve a lot of these issues. And ultimately, just really struggle with the whole idea, because performance-based systems seem to work well in the private sector. And I just don't know why we're painting such a broad brush here and really jumping to the conclusion that these programs are pretty much bad unless you have this amorphous concept of what's a modest reward.
Right. Yeah, and of course there's some language in the memo that would indicate, they're not saying simply on its face that they're going to find a violation of Section 11C because you have such a program. And so they're leaving the door open, I think, to including incentives in some fashion. There's going to have to be that balance. I think Brad may have alluded to this, or maybe not, but it could be that we are going to have some employers step up and if challenged or cited for these types of things, take it to the next level. We've seen some very good court decisions recently dealing with some of the practices that OSHA has put forward, whether it be the recent decision on the statute of limitations applicable to record-keeping violations or other issues. And so it may take that, and then always that does take time to work through that system and someone willing to challenge it and go in and try to get some more guidance from the court. But, I think ideally an employer might try to continue to use incentives on some level as part of maybe a broader approach, whereas they may have had really most of the emphasis on that system that would be a metric and then would reward recordable injuries, maybe turn instead and make that a portion of something that could be part of a safety bonus. In other words, if all the employees attended the meetings, took part in the various components of the training aspect of it, and then also look at that metric such that the whole of it went into whether or not that incentive came through. Roberta, maybe some advice you might want to share with us, or sort of a wrap up on what we can do in the meantime, because it's going to be a while before we get those court decisions and more guidance.
All right, and we may not for a while, or they may not comment on this. I think the first thing that employers have to do is examine their current policies to see what the practice is, because there are some things that it seems clear that would be frowned upon. And I think the nutshell version is if you have any across-the-board policies, we're going to discipline everyone, who's injured on the job, or you only have 48 hours to report your injury. After that, it won't be considered an on-the-job injury. Anything that's a one-size-fits-all, I think, frankly, at this point, would be not advisable. And I think that you need to look at each situation, know your workforce, and know what motivates your people, and come up with an appropriate incentive program. It's a requirement to record injuries. So you're going to have to turn in to OSHA the number of accidents and injuries that you have. So you're going to have that information. The question is, is it permitted to consider that in terms of some sort of incentive program? And I come back to, how will you know if your program is successful if you aren't allowed to at least consider the fact of accidents and injuries? We talked earlier, if you award, a pizza or a T-shirt to everyone who attended the safety program, while it's good to get them to attend, it doesn't tell you what sort of progress you're making. You have to have a way to measure the progress, and one component of that just has to be the number of recordable injuries.
Great. Could you talk a little bit about the other issues that are addressed in the memo that they've scrutinized a little bit, sort of on the stick side of it versus the carrot side?
Well, I think that we've talked a bit about across-the-board disciplining of all injured workers. Where you're disciplining them because they've been injured automatically, I think that's probably not a good practice. If you're disciplining them because they were injured while violating a safety policy, then I think you have to discipline them. But I think you have to be consistent in your discipline. If it's the sort of violation that you've never disciplined other people for, then you wouldn't start now.
Right. I think the memo specifically talks about that, and I think points out that just by disciplining everyone doesn't mean that you're not discriminating. They still think it's discriminatory because it has to do with people who've been injured or reported an accident.
Absolutely. I think a lot of employers feel like if we treat everyone the same, we can't be accused of discrimination. While that might be true under other federal statutes, it doesn't work here. You know, I think one of the keys here is to look at each situation individually. I think that if you terminate employees because they have too many injuries, I think that would be frowned upon. If you terminate them because they have too many violations of safety rules, that would be acceptable. And I think the only way to know is to investigate each and every case and therefore be consistent. You know, it's a bit of a catch-22 here in the sense that we talked about this earlier. If you do not discipline employees who violate safety rules, then you could potentially be fined if someone's injured or dies. I mean, you run the risk of being in trouble with OSHA for other reasons. So, you know, I lean towards, if you're an employer, I would think you want to have all the information that you can have. You know, any information from an employee is good information. You're free to disregard it. So you want to know what's going on out there.
Yeah. And you talk about being in trouble, you know, civilly, but Chris, you deal with situations that a lot of times have some pretty strong criminal implications too, in some of these safety inquiries, don't you?
Yeah, the criminal piece can always hang out there, and the criminal piece can take a whole lot of different forms. I mean, it could be anything as I'll call it as mild as a negligent homicide prosecution or something along those lines, or involuntary manslaughter. But these things can actually get pretty ugly, and I think you may have mentioned early on that they're looking for a lot more in terms of willful violations and things like that.
Right.
And when there's a fatality combined with a willful violation, that's automatically referred to be looked at for criminal prosecution. So folks need to be concerned about that as well. So,
but I thought it was interesting you'd mentioned outside the meeting today that when those come up, the sentencing guidelines actually look at how an employer has disciplined past safety violations.
Yeah, it's all part of that incentive and insurance piece, and there's it's not just the sentencing guidelines, which I think have really been changed somewhat because of the Booker decision a few years ago, but we still have the DOJ prosecution memorandum, which are out there and really echo what's in the sentencing guidelines, which I still use as a good tool anyway. And these things just really do need to be looked at in the context of where could you be? Do you have an effective compliance program? And the effectiveness of that program will make a difference in both the decision to prosecute and in what kind of sentence might get handed down.
Yeah, so while we've got OSHA here saying we're going to look carefully at your practices as far as disciplining people, there's a second side to that employers need to be worried about, whether it's, as Roberta mentioned, a civil lawsuit by the survivor or by the survivors of a deceased employee, or whether it's criminal prosecution. Roberta, I didn't mean to interrupt you. I just wanted to...
No, it's fine.
Point.
I think Chris made some good points, good practical experience out there. When we're looking at disciplining employers for not reporting, I think we're back to a case-by-case basis here, Nathan. I think if you have an employee that didn't report because he wasn't aware he was injured, he didn't follow proper procedures and he lifted something heavy, and he felt a slight twinge, but it wasn't until a day or two later that he realized he was injured. So if you have a policy that says you must report within 24 hours or you must report within 48 hours, he would unintentionally run afoul of that policy and really, through no fault of his own, be a little tardy in reporting. I think if you were to discipline those people, I think OSHA would find that very well may run afoul of Section 11C, because you can't discriminate against an employee who reports an injury. And I know at a minimum, if it weren't a violation of statute, the practice would certainly be frowned on. So, you do have a legitimate right to establish a procedure. Most employers don't want to learn 6 months or a year later, and I've seen that happen,
Sure.
that an employee had an on-the-job injury, because it impedes their ability to really fix the problem or to investigate. I think you have to be reasonable with your policy and with your investigation here, and certainly with any discipline.
Right. I think some of the points on this next slide are some of the things that you had alluded to when you were talking about the issue that OSHA raised. And certainly, consistency and reasonableness. I think, Roberta, you probably give the same advice to your clients that, when you step back and look at how would a disinterested, reasonable person look at how you're handling this particular situation when it comes to employment discipline, would they look at it as being fair under all the circumstances? That kind of an eye toward dealing with these occasional issues that may come up where somebody couldn't follow the procedure.
It's almost like you have a narrow aisle here, Nathan. If you don't take any action, you don't discipline for failure to report or for reporting untimely, then you'll be in trouble for not having an effective program, for not trying to find these problems, for not trying to fix them. But if you automatically discipline everyone who fails to report within a set period, then you've fallen outside of what they recommend. So it really is, it's become a more narrow path here for employers to stay out of trouble.
Right. Well, and of course, OSHA has sounded off on this issue, and they cast it in terms of an employer attempting to use a work rule as a pretext for discrimination against an injured employee. But some of their advice still is good, I think. They talk about looking at it on a case-by-case basis, which is what I think you recommended, and asking whether equivalent discipline's been imposed in other situations. So again, consistency. Some of the things I think we preach just throughout employment law to our clients important there. Was this done where someone was not injured and violated a rule? And again, all this plays back into what we've been talking about in terms of building those defenses for various claims that might come to an employer. Just any follow-up, Roberta, on what you think employers should do along these lines in dealing with these discipline issues?
I think we've all talked about, getting more information from OSHA, but until that happens, it hasn't happened. So I think you do have to set up a program. I think to not have a safety program in this day and age would just be very foolish. And I think most large companies do have safety programs, and I think you guys have mentioned that in the last few years the emphasis on safety for most companies has increased. Most companies do have safety training. It's more effective than it's been in the past, and they do have programs that have been effective. We saw that at the very beginning by the slides that Brad showed us, where the rate of injuries and fatalities have gone down. So I think a lot of employers, it would seem, are doing the right thing. So first and foremost, if you don't have any sort of safety program, you should get one. And I think in setting up that safety program, you need to figure out what makes the most sense for your company. What sort of incentives do you need to have for your employees? And I think you need to set up a discipline program. I think even though the memo is critical of discipline programs, I think you have to have one. I mean, let's be honest here. People respond. I mean, nobody wants to be hurt. But if you had an injury and you felt like you weren't all that hurt, you might consider not reporting. But if not reporting is a violation of your company's program and you might be discovered for not reporting, then I think it should incentivize you to report. I think you have to have the carrot and the stick.
Yeah. And I think most companies that we see and deal with do make it a violation of policy not to report, and they're very, very strict. They want to know everything, whether it's a first aid case or something more serious, because their goal, quite frankly, is to stay between the lines in terms of compliance. And when they're filing their OSHA 300 reports and posting them and everything, they want that stuff to be done right. And maybe there's a few bad players out there, but I just hate to see all the good folks that have made a lot of good progress take a step back because there might be a few bad ones.
So even though OSHA is discouraging of the stick part, I guess, I think it's still necessary. I mean, you have to discipline employees who don't report an on-the-job injury or who won't cooperate in an investigation. I mean, I think you have to have, or who violate safety rules where you have the evidence that they in fact did. You have to have that discipline program. And I think you need the incentive program, too. I think that's just how most people respond. And so their shift in the memo seems to be, instead of, rewarding the 100 days without an accident sort of program, they want you to reward the employee for attending the safety program. And while it's not wrong to reward for attending the safety program, I think employees take great pride in having 100 days without an injury. And I think if you know your people and you are willing to investigate any sort of complaint, and most publicly traded companies have, a 1-800 number or a way to report complaints. And so if you truly follow up on all of those and investigate, then I think you'd be fine having the incentive and the discipline program.
Right. And I agree. I think at the end of the day, the only downside might be that you have an intermediate situation where you get an investigator that's trying to take this guidance too literally or too much to heart and does find some type of a violation, and then you've got the burden of what do you do next? How far are you willing to fight it? But from an overall standpoint, I think a lot of companies are probably going to find that it may be worth that risk to continue to use these elements in maybe a modified fashion because the benefits are there to everyone, to the safety of the workforce.
Don't you think, Chris, that the problem may come in with a whistleblower investigation because OSHA is protective, somewhat, I think, protective of whistleblowers?
Yeah, I agree. The whistleblower situation, and we all have seen them and have our own feelings about how they arise, but too often they arise in situations where it's not so much a whistleblower, but someone trying to claim whistleblower status for other reasons. And if we get into presumptions where those are thrown out there as issues, and this becomes part of the equation, it just gets far more time-consuming, expensive, and frankly, it's disruptive to focusing on doing what you're supposed to be doing, whether you're making a product, and in particular, making a product safely. So,
good point.
Yeah, I think the one clear takeaway is that there's going to be a lot of scrutiny when OSHA comes out, whether it's as part of an investigation or part of a complaint from someone who's disgruntled with some issue, and that again, it's just going to take more time, and it's going to be a distraction from other things, but employers are going to have to focus on ways to balance these issues and make sure that they're being consistently implemented. So,
yep.
That just about takes us to our finish-up point. We've got a few wrap-up comments. We appreciate everyone's participation.
I wanted to remind you of a couple of webinars already scheduled in the coming few weeks. The next one will be in 2 weeks on Wednesday, June 27th, and this will be on employer group health plan renewals. For those of you involved in that renewal process, it can often be a difficult, confusing, and anxious exercise as you try to weigh all of the different factors in there and coming up with the best plan possible for the coming year. And whether your plan is fully insured or self-funded, the old adage that information is power certainly applies here. Starting early and proactively arming yourself with meaningful, actionable information, along with data and analytics, can make all the difference as to whether you end up a hostage or a hero in the renewal process. Employee Benefits attorney Bill Frudenrich will be joined by Employee Benefits and Risk Management consultants Tia Corley and Todd Neves from Premier Source to review key renewal strategies for both self-funded and fully insured plans. And for plan sponsors who are unsure of whether it makes economic sense to switch from fully insured to self-funded, the panels will also review common strategies and key decision points for making that determination. Some employers who are fully insured found it was actually a better option to become self-funded. The next webinar after that will be on July 18th, and employment attorneys Kathy Neal and Sherilyn Whiting-Ralston will discuss best practices for handling harassment complaints. Ignoring such employee claims can be costly for employers, and harassment complaints that are not investigated, documented, or handled correctly can lead to on-the-job performance issues with the complaining employee, or even worse, lawsuits that often include a claim of wrongful discharge or retaliation. During this webinar, Kathy and Sherilyn will offer practical tips for properly investigating a harassment complaint and dealing with the complaining employee going forward and avoiding costly litigation. I also want to note that we are anticipating even more webinars this summer, including on the hot topic of healthcare reform. Employers, the employee benefits community, and the general public are eagerly awaiting the U.S. Supreme Court's impending decision that could have far-reaching, profound implications for everyone and create even more uncertainty for American businesses in the short term. You can find out about this and the already scheduled webinars on our EmployerLINC website, and you can find that at EmployerLINC.com/upcoming. In addition to the webinar announcements and other resources, you can keep up with the latest news and commentary about regulatory developments, agency actions and enforcement trends, and all the legal issues affecting employers and the workplace at EmployerLINC.com. The website has recently gained some national exposure from other employment law and HR websites. So if you haven't already visited, check us out at EmployerLINC.com. I want to thank Roberta Fields, Chris Paul, and Nathan Watley for presenting today's webinar. And on behalf of the McAfee and Taft Law Firm and its 180 attorneys, thank you for taking time out of your busy day to join us for another EmployerLINC webinar. See you next time, and have a great afternoon.